Hello, this webinar is a part of the U.S. Constitution series, and this one's titled, All Three Branches Are Responsible for Upholding and Safeguarding It. Well, the U.S. Constitution provides for these three branches of government, and in another webinar we took a look at the system of checks on power that exists between the branches. But there's another check on power, and that concept is that all three branches are responsible for upholding and safeguarding the Constitution. This is different than what we've been taught today. We've been led to believe that the Supreme Court keeps the Constitution in its hip pocket and dictates to Congress and President what it ultimately means. The founders did not think this way. One of the reasons that we've moved to this way of thinking is the concept of judicial review. The concept of judicial review is this. It's where judges review court cases and comments from other judges and give them greater standing than the Constitution itself. It gives unwarranted power to the courts to twist the Constitution's meaning. You see, it puts judges and their opinions over the Constitution. Judicial review holds the Constitution hostage to the opinion of judges versus the plain text of the Constitution. The founders did not believe in this method of constitutional interpretation. So the net effect is that the Constitution and its plain meaning is less used by the Supreme Court than judges that set precedent through rulings, and then those precedences are referred to rather than the Constitution itself, and then the Supreme Court declares what the Constitution means in its mind. This leads citizens to believe that the Constitution is mysterious, complex, hard to understand. What they don't know is with a little bit of study and proper guidance, the Constitution can be understood. Thomas Jefferson had some strong feelings about this. The Constitution is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. The germ of dissolution of our federal government is in the federal judiciary, an irresponsible body, for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little bit today and a little bit tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction, until all shall be usurped from the states. Jefferson from the very beginning had a concern that the Supreme Court and the federal court system would usurp power and expand their reach and basically take over the states and their rights. He had a proper understanding that the Congress, the President, and the Supreme Court all were responsible for constitutional safeguarding. Here's another quote. Nothing in the Constitution has given them, the federal judges, a right to decide for the executive, more than to the executive to decide for them. But the opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislative and executive also in their spheres, would make the judiciary a very despotic branch. And what he's saying here is if public opinion or government officials adhere to the view that the Supreme Court is the final authority and not the court, the legislator, and the executive, all in dynamic tension, holding and safeguarding the Constitution and its proper bounds, then the legislative and executive would be surrendering power to the courts, and that would make the courts a despotic branch indeed. President Andrew Jackson, over 50 years later, made the same case. In July 10, 1832, in a veto message, he was addressing the issue that the Supreme Court had made about the constitutionality of a national bank. He was making the case that just because Congress had passed a law or the Supreme Court upheld a law does not make the law constitutional. Jackson makes the case that the President is an equal party in the three branches in defending the Constitution. In the first part of his message, he takes on the idea of precedent and how precedent does not equal constitutionality. It is maintained by the advocates of the bank that its constitutionality, that is the constitutionality of the national bank, and all its features ought to be considered as settled by precedent and by the decision of the Supreme Court. To this conclusion I cannot assent. Mere precedent is a dangerous source of authority and should not be regarded as deciding questions of constitutional power. except where the acquiescence of the people and the states can be considered as well settled. This is a really bold statement. He's saying that just because something has been passed into law and that the Supreme Court says it's constitutional, that does not mean that it's established law and should never be revisited. In this particular case, it's rather remarkable because Congress had, in 1791, decided in favor of a national bank, in 1811 decided against it, in 1815 decided against it, and in 1816 decided in its favor. At a state level, the number of governors, legislative, and judicial opinions against a national bank were opposed to it 4-1, and yet it had become law and the Supreme Court had said it was constitutional, but for the veto of Andrew Jackson. And this in his message went on to say about the aspect of all three branches being responsible for safeguarding the Constitution. If the opinion of the Supreme Court covered the whole ground of this act, it ought not to control the coordinate authorities of this government. It is as much the duty of the House of Representatives, of the Senate, and of the President to decide upon the constitutionality of any bill or resolution which may be presented to them for passage or approval, as it is of the supreme judges when it may be brought before them for a judicial decision. The opinion of the judges has no more authority over Congress than the opinion of Congress has over the judges, and on that point the President is independent of both. The authority of the Supreme Court must not, therefore, be permitted to control the Congress or the executive when acting in their legislative capacities, but to have only such influence as the force of their reasoning may deserve. So this idea was being thrown out. The Supreme Court is the final authority on what the Constitution says, particularly based on judicial precedent or judicial review. Both Jefferson and Jackson were throwing this idea out and reestablishing the founding idea that all three branches are designed to uphold and safeguard the Constitution. I hope this has given you food for thought. My name's Craig Seibert. Thanks for listening.